All right. Good evening, everyone, and welcome back to the C Show. I'm Chris, your host, and tonight with me I got Larry Ginsberg, who is an attorney. How are you, Larry?
Doing fine, thanks, Chris.
Great, man. Glad to have you on. So,
Thank you.
Larry, I'm good. Thanks, man. Thank you for asking. So, you're an attorney or retired attorney, correct?
Correct. I retired about a year and a half ago.
Okay. Well, before we get started, tell us a little bit about yourself, Larry. Your background, where you went to school, where you from, just basic biographical stuff about you.
Okay, well, I was born in Providence, Rhode Island on Friday, April 13th, 1951.
Oh, happy
Um,
birthday!
Thank you. I was actually lived in North Attleboro, Massachusetts. Providence was the hospital where my mother's gynecologist had rights to practice.
Okay.
I grew up in Massachusetts, lived there for my first 13 and a half years, had my bar mitzvah in Attleboro, Massachusetts.
Huh.
Big New England uh, baseball, football, basketball, hockey fan, even
All
though I
right.
moved to, pardon?
I said, all right. I mean, I like some New England Patriots. Glad you're into sports.
Yep. I love sports, follow them for a long time. I also, the way we met was through this, your Civil War group, the Killer Angels.
Yep.
Um, I became fascinated with the Civil War for the 100th anniversary from 1961 to 65. I was a
What was it?
stamp.
I'm sorry, Larry, to catch you up. What was it that got you fascinated in the Civil War? Just by the way, for everybody, Larry's a moderator on the group, the Killer Angels. For any of y'all like to join, hit us up. But just curiosity to start with, what got you interested in it or fascinated in it?
Actually, two things. One, I was a stamp collector at the time,
Uh
and
huh.
they put out a set of Civil War stamps on some of the major battles between 1961 and 1965, corresponding
Yeah.
with Fort Sumter in 1861 and the Wilderness and a few others. And also, I was a baseball card collector, but they put out a series of 80 Civil War cards. So I got into them and I
Oh,
collected
really?
them, and
Okay.
they were very interesting. I could still actually remember some of them. There was one about a little 15-year-old boy who was hanged as a spy. That one, for some reason, I've always remembered, and I remember the first one on First Bull Run, which was a very interesting one, and a few others.
Okay. All right. So you got interested in you got interested in Hunter anniversary, and then what? What happened after then?
Well,
After
after that, basically, I read some books and that type of thing, and I just got interested and followed it.
no, I mean,
Uh,
no, I mean from what I mean
no,
is
I understand. I'm getting there. My
we'll come
father
back from
was
there to that
a
one now.
my father was a plumber. He was a
Yeah.
civilian employee for the Navy. He had fought in the
Huh?
Navy during World War II, but
Okay.
he was a New Yorker. He met my mom at a dance in Davisville, Rhode Island, which was where the Seabees main headquarters was on the East Coast. They got
Okay.
married, and then he moved to Massachusetts to be with her. But in 1964, he became a member of the Plumbers Union in New York and got a job, and we moved to New York, and I ended up living in Queens. Went to high school at Springfield Gardens, which is a brand new high school in Queens. Then I went to college at Stony Brook, which was part of the State University of New York system. I ended up a psychology major, and I went to law school up in Buffalo. It was
Uh-huh.
also State University of New York school. So I spent 3 years up in Buffalo, and I
Yeah.
had actually pretty mild weather for Buffalo. And I actually, interestingly, I became interested in the law between my junior and senior year in college, I did 3 months in Europe and Israel, backpacking, Ural Pass, that type of thing. We ended up in England, and that was the last week. And I took a tour of Parliament, and it was supposed to be a rainy day that day. So when I took the Parliament tour, I ended up getting lost in the archives. So I was reading about legal cases from the 1400s and the 1500s and 1600s, and I became fascinated, and that's when I went into law. I did as a scholar, my best field was criminal law. I did a lot of work on litigation, prisoners' rights litigation through Professor Herman Schwartz, who was a very liberal professor. He ultimately became a chief counsel for a couple of the Senate committees on criminal law and criminal justice. I
Really?
also had one of my cousins from Massachusetts was the dean of criminal justice at Northeastern University in Boston. So he and I also often talked. He was
So
actually my mother's first cousin.
what what other cases stand out or things that you worked on that you what was the most interesting one that you found that you handled?
Well, in law school, it was just after the it was just after the Attica prison riot in New York,
Oh,
and
really?
yeah,
Tell me about
so
that.
Herman Schwartz was one of the defense attorneys for some of the prisoners who were accused of crimes, various crimes that happened during the Attica riot, and so I was involved in that, doing research, visiting prisoners, interviewing prisoners. Um, it was uncanny. I mean, I don't know if, and I hope it never happens to any of you, but when you walk into a prison like Attica, it's just quiet. You could hear a pin drop. Nobody makes any sounds. People just shuffle around when the guards are taking prisoners out. It felt like you were in a different world, a fortress. Um, we represented a couple of prisoners who were accused of murder. By the time I left law school, the cases were still pending, so I wasn't involved in anything other than initial research and interviews. I did interview some of the other prisoners for witnesses, so that was interesting. And another
Fascinating, right?
Yeah, it certainly was. And another thing I did with Professor Schwartz was I worked on some of the Nixon tapes, not
Wait, what
Watergate.
now?
I worked on some of the President Nixon tapes.
Which
Uh,
tapes?
I had the Nixon, aside from Watergate, he also was involved in some dirty tricks against
Right.
Democrats in the 1972 election. He had a fellow, I don't know if anybody of you remember him, but the last name was Segretti. And he was the dirty tricks master. He would interrupt Democratic phone calls. He would have
Kind
his
of like the
people.
Roger Stone of our day.
Yeah, basically, he would have his people infiltrate and try to disrupt Democratic meetings and campaign speeches and that type of thing.
Well, what
And
would they
so,
do? Would they send people there to interrupt the speech, like
yes,
hecklers? Okay.
yeah, and they also tried to tap the Democratic headquarters and that type of thing,
Yeah, I think
which
I
did
remember something about that. Them tapping some headquarters or something.
right. Well, that was basically what they tried to do in Watergate also. But again, I was only, law school's only 3 years, so I started it. I did a lot of work, And then unfortunately, it still went on after I was gone, and somebody else picked it up. Though
So
I
I'm
worked
sorry. Go ahead.
with Ramsey Clark, who was,
Ramsey Clark, really? Wow.
and I worked
I'm
with
sorry. Go ahead.
Bill
Well, the
Hunter.
reason Ramsey Clark, me studying the Kennedy assassination, the first thing popped in my mind was the Clark panel. So I'm sorry. Go ahead. Go ahead, Larry. You worked with Ramsey Clark.
I also worked with Bill Kunstler, William Kunstler, who was a very famous criminal attorney. And what
Uh-huh.
we would do, what I was doing was I was nothing all that fascinating. I was doing a record and a report on federal wiretapping. So I did a lot of work and I had a lot of evidence and based on it. But again, I did my report and I got my honors with distinction and graduated, and then went into the law in New York.
So
Um,
sorry, I don't want to. Tell me more about the Nixon dirty campaign tricks. I mean, were they doing it to all the Democratic candidates? Were they?
so it was basically McGovern, in the presidential race.
Wait, what about in the primaries though? Because um, from what I've read, and I'll tell you about this in just a minute, that he was absolutely terrified of a matchup with Wallace.
He was, but he didn't really do anything to Wallace. He was Wallace at that time was already doing third party, and
Hmm.
as soon as
But,
he
I'm
wasn't
sorry,
a
but
mainstream Democrat at that time.
so
Democrats
Wallace,
were
we're talking about the 72 race, right?
correct.
Wallace
Yes,
Wallace was running in the Democratic primary in 72. When Wallace got shot, he was actually ahead of McGovern by 2-1 in delegates, and I think it had 1 million more votes, and was going to be the Democratic nominee. He
well,
got after he got shot.
you know, you might be right, but I don't remember it that way. It would seem that McGovern, I don't know, that McGovern was going to sweep the North and the West. So I think no matter what was going to happen, McGovern was going to be the candidate.
Back in those days, it's not like it is today. Where you walk in with the delegates, you walk in with the votes, and you get the nominee. Back in those days, I can, because I've studied a lot of this. The guy who had the most delegates didn't get the nomination.
Oh, he had to get the majority. He had to get a majority. Basically the same way it is today.
Well, no, in those days, like 64, 68, the guys who got, they didn't do it like it was today where they went into the roll call. You had guys that, would finish third with delegates and ended up getting the nomination. I don't know when that actually stopped. They changed. Yeah, they changed all that. So I think that you're correct that even had Wallace went in there with the delegates, with the votes, with the states, the party would have said, no, we're not giving you the nomination.
Well, what I think historically, you're on the right track, but the way I remember it and the way I remember my history was you still had to get the majority of the delegates, but there were so many, home staters and that type of thing that very rarely would you get into the conventions with the majority of the delegates.
Oh,
So let's say you needed
that's what you're saying.
170 delegates to win.
Yeah.
Actually, let's use some. Let's say for simplicity's sake, you needed 1,000 delegates to win. The top guy came in with 850, and you had favorite sons winning states and everything else. So what happened was, for either the first or the second ballot, according to the states, you had to vote where your states told you to
Right.
vote. But then after that, you could vote your own way. And so if you go back, there are a lot of conventions that had 17 or 18 votes before they agreed on a
Yeah.
candidate.
I believe you're correct on that.
So
Anyway, I'm sorry to get off topic.
And I remember William Jennings Bryan, who ran for the presidency 3 times, never got elected on the first ballot for the Democratic convention, and
I'll
because
have to bring you on. I'm fixing to start a thing with election cycles where we talk about previous elections. You'll be the perfect person I could have for my host on that. Sorry, I didn't mean to cut you off. The reason I was asking that about the dirty tricks and Wallace was I read a book about Wallace, and in the 1970s governor's race, the Nixon campaign had pumped $500,000 into the Bremer campaign to try to defeat Wallace, and you can imagine what that is in today's money.
oh yeah,
So but he was but he was scared of Wallace. But so the Nixon dirty tricks. I mean, wiretapping phones,
wiretapping phones, interrupting convention speeches, interrupting campaign speeches. Basically, as you said, basically Nixon was paranoid. All the polls, none of the polls showed McGovern with a chance to actually take him. And then do you remember when he picked Tom Eagleton as his vice presidential candidate?
Well, I've read about it. Yeah.
Yeah, I know you're a bit young. Eagleton had some mental issues, so he was picked as the vice presidential candidate. Obviously the Democrats didn't do their vetting. Excuse me. So they kicked him off the ticket. They picked up Sergeant Shriver, who was a Kennedy relative. He was married to one of JFK's sisters. And you had basically you had a New England, South Dakota candidacy. And if I remember correctly, the only state they won was Massachusetts, and they won the District of Columbia.
You are correct on that. McGovern didn't carry his home state.
Right. But President Nixon was, as you said, was paranoid. And
is there anything that he actually did illegal during these dirty tricks?
Well, after there was there was a case called the United States against the United States District Court, and that set basically the rules for what you needed to do for a legal wiretap, and it also set other rules. And so Nixon did not follow the rules for a legal wiretap at any time. At any time, I don't think when you pay somebody to disrupt the campaign or something, it's probably not illegal, or actually it's definitely illegal now. It probably wasn't illegal then because it was done all the time. If you look back at presidential elections, that they were, the candidates were insulted, that they were.
Well, let me ask you this. I'm sorry, I didn't mean to cut you off. Okay, so it's probably not, like you said, illegal, but unethical. How is this legal today? Like, I don't know how familiar are you with it, but 4 years ago there was a race in Alabama for the Senate between Doug Jones and Roy Moore, and Moore was a very controversial figure, polarizing.
I remember the race, yes.
Well, all of these allegations came out about Moore that 4 weeks ago before the race, and some of the stuff I'd never heard of before, and Moore had been around for years, and some of us all kind of dropped away now. But there was a guy, and I watched him on CNN one night, and he was talking about the stuff that Facebook does right now, and of course we're all familiar with Facebook. But he said that he said that the Democratic Party paid him $1 million to sit behind a computer and to make up false Facebook posts regarding Roy Moore. And I
Well,
thought, what
it
is
may not have been illegal then. It certainly is illegal now.
okay?
The you know there's lines that you cross, and what happens was that there used to be a fairness document on political media. Again, excuse me, that if you had granted certain time to one candidate, you had to grant equal time to another candidate. That's no longer the case. There, you know, there's been a lot of election rules that have become legal, have become illegal, have become legal again, depending on the party in power and what they're going to do, depending upon what the Supreme Court says. So political, politics in general is very interesting. Because people try to get away with anything they can. You've of course heard the old sayings from Chicago and New York: vote early and vote often.
Yeah, I love that.
Well, Plunkett, who was one of the Tammany Hall, New York politicians in the 1890s, wrote a book, and I remember reading it in college. And one of the things is, in order to get in with Tammany Hall at the day, you had to control a vote. Now, this was before women's votes, so you can't say, oh, I control my wife's votes or anything like that. But what he recommended was that you talk to a couple guys who live on the block. You talk to a couple of your relatives. You come into a Tammany Hall meeting. You can even, in those days, you could go up to Plunkett or any of them and you'd say, look, I can control 5 votes in this district, or I can control 50 votes in this district. What can you do for me to get me to have these 50 people vote for you? And it was like a sale of pork. We can give your district a bathhouse. We can give your district a new firehouse. We can give your district more police. We can give your district an extra councilman on the Democratic
Oh yeah, they've changed. um, I mean, many things like that. Sorry, I didn't mean to cut you off, Larry. Hey, so Larry, so you worked on that. So tell me, what area of law did you practice over your career? How many years did you practice total?
I practiced 42 years.
42
Uh,
years.
I,
Okay.
I was admitted to the bar in 1977, and I retired in 2019. Um, I started out with a small 2-man criminal defense team. We were in Manhattan, but we worked in the Bronx. At this point, I had graduated New York, and I was living in Manhattan. Um, so we did a lot of 18B work. Now, what 18B work was when legal aid could not handle a client, 18B counsel was paid to handle that client. A lot of the times, if 2 guys were charged with a crime, aiding and abetting, working together, both defendants, and in those days, only one of them could be represented by legal aid, and the other had to be represented by 18B. So
Oh wow.
I learned a lot about the criminal law. I represented a lot of petty criminals, how do you want to say it? Small time hoods, that type of stuff. I was working with these guys. They had both been former ADAs in the Bronx. So they were on the panel. Names was Salvatore Lasco and Patterson. I'm drawing a blank on his first
Mob
name.
connections?
Pardon?
They have mob connections?
Alasco did, but only some of the minor hoods. You know,
Wait, I'm sorry. So
we were nowhere near the Gotti League or the
but you did
you know,
represent some mob figures.
pardon?
But you did represent some mob figures.
Lower level, yes,
Sorry,
we represented them.
sorry, I didn't mean to cut you off. Go ahead.
Pardon?
I said I'm sorry. I didn't mean to cut you off. Go ahead. Tell me about you was telling me about the 18B and
Yeah,
the
well, that was it. So what would happen is an 18B council, we would go to court, and we would then be given cases by the legal aid attorneys that they couldn't handle. So we would represent them in the arraignment, and then it would our decision if we wanted to continue representing them or not. Sal Alasko really enjoyed the 18B work, so we took quite a few 18B councils cases, and I did most of the research. I did some of the cases. The first case I ever did was in Queens County. It was not 18B, but it was a case for a person who exposed himself to two women walking down a street in Queens Village. And we came to court to do the case. And I got my first victory when the women did not show up to testify.
Hey, a win's a win.
Basically, a win is a win. And as you do these things, you learn certain tricks. Now, in
Hey,
New
let me ask
York,
you one. Sorry, let me cut you off again. Let me ask you a question. When you're trying a case
yeah,
and you go in there and you've tried it and you feel like that, we're not even talking about whether your client's truly or guilty or not, but you feel like that you out-tried that guy, you won that case, and you get a guilty verdict. Does it just piss you off? I mean, because I'm of the opinion that a lawyer's like anybody else, a doctor, football coach, boxer, they don't want to lose. You want to, I mean,
absolutely. We do not want to lose.
because I had a misdemeanor case one time, and where my lawyer represented me. I mean, it was nothing major. If I would have just played smart and just went through the little hoops, they would have dropped my little it was a DUI case. They would have dropped my charge against me, and I would have went through the court referral stuff or whatever and dropped the case.
Exactly.
But my lawyer goes, "No, we're going to fight this," and we take it to court. He takes it to a jury trial. DUI on jury trial.
God, no.
The final things was like they had 3 tickets on me, $1,500 fine, had to go meet with the little court referral officer, take a alcohol test and just check in with him. 6 months, it's over with. The case gets off my record and everything like that. And my attorney's like, "No, we can beat this. We can beat this." So me being stupid, we reject everything. So the final day we get in there and the judge is like, they come out there and the prosecution has the final offer. They was going to drop all 3 cases, no court referral, pay a $250 fine, plead guilty, and walk out. And I looked at my lawyer and I said, "But I'm still going to have a DUI on my case, right?" And he said, "Yeah, you'll still have the DUI conviction." And I said, "Well, we've took it this far. I guess there's really no sense in turning back now." And he said, "You want to try it?" And he said, "Yep." He said, "All right, let's try the case." So he goes out there anyway. We had a jury that was out for 5 hours.
Wow.
And first thing I said, when it was over with, he was just enraged. He was kicking garbage cans over me. He was hitting walls because that's when I got it. Then he was mad because he didn't want to lose. So I just wondered if you experienced, had that too, just anger, you don't want to lose.
You have to analyze all your cases. I mean, I was a litigator. I was a criminal defense attorney. I never tried a case to a jury. The few times I was going to go to a jury, we settled beforehand. I tried many cases in front of judges. I've tried many cases in front of administrative bodies. I also did a lot of juvenile defense work, and those are always tried in front of judges. But I never. The only time I got to pick a jury was in trial practice in law school. Always
Interesting.
one, but never happened in 42 years. Never went to a jury trial.
Really?
Yeah.
I mean, I guess that's probably a good thing that you could have worked it out, before going to court.
Well,
what I've noticed. I'm sorry. Go
the
ahead.
thing is, the thing is, in a civil trial, a civil case is not like a criminal case.
Right.
You try to. Most of the judges, or many of the judges, will never let you get to a civil trial. Cases can be settled because when you're in a civil trial, well, it's either, for the most part, it's either all or nothing. You either win and you get damages, or you lose and you pay damages, or you lose and you get nothing. So, if you have a case and you think the case is worth 100,000, but you have in your mind, and you still have, and if you're representing the plaintiff, it's your burden of proof, so you have to prove it by preponderance of the evidence, 51% of the evidence, depending on what state you're in or whatever. And you think, well, I have, in my mind, I have a 60-40 chance of winning the case. So if I think it's ultimately worth $100,000 and he's going to offer me 65,000, I'm going to recommend my client take it. And in a civil case, that's what normally happens. I mean, I had a case where they offered my client $40,000. I recommended that my client take the case. My client said, no, we're going to win this case. I did a great job, but we didn't win the case, and he got nothing.
Oh, wow. Wow.
That was the only case that I actually had something like that happen. I mean, there were smaller cases. I had a housing case where the other attorney offered my client, we were the landlord, the other attorney offered my client $4,000. My client was adamantly against it. So we did the trial. My client, and I personally, I recommended the $4,000 because the most he was going to win was $6,500. And it was going to be a day and a half, 2-day trial. He'd be paying me more in legal fees than it would have been worth for him. So we did the trial. The judge awarded him $4,700. So he won, in his mind, $700, and he paid all that and a lot more to me. So I mean, you have to be, you don't want to lose. And in a criminal matter, and I don't know what it's like where you are in Alabama, but in New York and in Connecticut, and at least a lot of other states where I know attorneys in, the vast majority of criminal cases are plea bargained and settled.
Yeah, I mean, I think, with the most cases, they try to work out a plea bargain.
Right. I would hope so because they don't have, you don't have the money and you don't have the.
In Alabama, let me rephrase that. I don't know what Alabama is. In Alabama, the way our law is written, I know a guy who he is one of the. In Alabama, if you get, of course, like all states, I guess they get automatic appeals, but appeals to the death penalty, if you get appeals. He is one of the only. There's only a handful of defense attorneys in Alabama who are certified to handle death penalty appeals. He only seeks out capital murder cases. That's the only thing he wants to represent, because the way it's written now, the way it's written in Alabama, you can charge the state whatever you want in capital murder cases. So he can charge $30,000 for legal fees or whatever, for his fees on that right there. So that's why because he can bill the state. He was telling me about a case where he had a client that had committed some murders. It was a capital murder case, and they did DNA. Has proved to be his client's blood. He petitioned the court to have another DNA test did, was challenging the DNA results. The judge granted it. $40,000 later, the DNA still proved it was his client.
Yeah,
I think that's just a bit.
Well, the issue is that don't forget, James Madison said it's better that 100 guilty people go free than one innocent person be convicted and go to jail.
So I would agree with that to an extent.
To an extent,
but to an extent, it depends. If it's 100, guilty robberies versus a murder, yes, but
exactly. That's exactly the issue. But that's the way that's why many criminal defense attorneys, and there are times we know that our client is guilty, but the issue is not whether the client is guilty or not. The issue is whether the state can prove the case. In a criminal matter,
I asked him one time because he handled this case here in Alabama, and it was like everybody knew this woman was guilty. Just the story didn't make sense. Everybody knew it, and of course they take it to trial, and she's found guilty, and she's given the death penalty. So I asked him one time. I said, "Man, why don't you take that case?" I said, didn't you know she was guilty?" And he goes, I said, "You knew she was guilty?" He goes, "Well, she had means, motive, and opportunity. So, yeah, she was guilty." And I said, "Well, why did you take it?" He said, "Well, look, Chris," he said, "I've never had a client come in and say, 'Hey, I killed this guy, get me off.' He said, they come in, they tell me the story, and I go with the story. That's the best I can do." And I was like, okay, well, I can respect that.
Yeah, well, that's basically it. These people, as guilty as they are, they're entitled to a defense. That's the Miranda ruling. You're entitled to an attorney at certain points in the trial. You're entitled to an attorney at the trial itself. That's Gideon versus Wainwright. And the state has to prove you guilty, and it has to prove you guilty by a reasonable doubt. So what are you doing in the trial? You are trying to show that there is a reasonable doubt why your client should not be guilty. Now, I told you that the only time I did a jury trial was actually in law school, in trial practice class. And I was in front of, I don't remember, it was a 3-person jury or a 2-person jury. It was however many they could get. And I was representing the police at the case. I was the prosecutor with a guy who turned out to marry my cousin, and so he's now my cousin. Okay. We were doing the case, and the judge, who was our trial teacher, thought that the other side, the defense, had raised a reasonable doubt, but my 2 or 3 man jury said that we had covered all the reasonable doubts, and they convicted. So,
well, why didn't your judge issue? Because explain this to me as well, because I'm sure a lot of our viewers like to say this. Explain this to me. I'm sure that you remember it, and I remember it. Back in the 90s, they had that British nanny or pair or whatever, and the jury convicted her of killing that kid, and they convicted her guilty. Everybody screaming, and the judge issues the panel, and he sets aside the jury verdict and issues a verdict of not guilty from the bench. What is the precedent for them to do that? And if they do, can the prosecution appeal it to a higher court?
The prosecution can appeal those in most states. The issue is the issue is that the judge has to make the decision to let the trial go to the jury. If the judge in a criminal case in most states says that after closing arguments, the judge then has to decide whether there's sufficient evidence to let the trial go to the jury itself. So if the judge says, I believe that there's sufficient evidence, and then the jury comes back with a guilty verdict, then the judge can say no reasonable jury could have come back with that verdict, and he can overturn it or she can overturn it. And that's the only way that can be done. Because
can they do it
else,
on both verdicts? Like if a jury says guilty, they can say not guilty. If they say not guilty, they can say guilty?
No. If the jury comes back with a non-guilty verdict, that's it. The judge or no one else can do nothing there. The trial is over. The guy walks. I mean, he's saved from double jeopardy, except that in some cases the federal government can try him again for a federal violation, but the state cannot try him again. Even if he leaves the courtroom, has a press conference and said, I just got away with murder. The verdict, the jury freed me. It's over right there. Now, of course, he can be sued civilly for damages, or that the federal government can do a civil rights case against him, or an interesting case that I saw on one of the court TVs were that the guy was found not guilty of killing his girlfriend or his wife, and he was still in the military reserve. So what they did was they called him up to active duty, and they tried him federally for the case, and they convicted him.
That's pretty smooth right there. Was he charged? I'm sorry. Well, was he charged in federal? Was he tried in federal court, or was he tried in military court?
He was tried in the military courts.
Oh wow! Do you know what it takes for a conviction in a military court?
Oh yeah.
I mean, when I read about that, I was like, man, you might as well just get a judge to decide that case. If you're talking about, I think you have different ones, but you're talking about in a 12-person jury, 5 votes to convict. I would take. There's no way I'd get to a jury trial with that.
Right.
I'm sorry. Back to the one. So, so the juries came back and they found me guilty, and there's cheering, and the judge says no way,
no reasonable jury could have found you guilty, and then he could dismiss the cases. Now, depending on the state, I'm not sure.
Well, let's just say that. Okay. Or, anyway, just tell us both circumstances if the state can or cannot.
I'm not sure, to tell you the truth. I believe that the prosecution can appeal that, because it wasn't a final decision by a jury. It was the case was taken away from the jury.
No, I'm saying if the jury decided it and then the judge did it, and then the judge said it, if it's what's the if the judge says not guilty, and you said that some states they can appeal it, some can't. What happens there? I mean.
Well, it's correct. If the judge says it, because if the jury says non-guilty, then it cannot be appealed, as I said.
Right.
But if a judge says non-guilty, he's taken the case away from the jury. So he's actually having his judgment instead of the jury's judgment. So it probably can be appealed in most states. Now, I'm not 100% sure. I've never had that done. But I believe that case can be appealed because it's. So
what would the so something if like that is appealed? I know when it goes, when the client appeals, that and correct me if I'm wrong, the appellate court is looking for mistakes that like the judge made during the case,
errors of law.
So what are they looking at? I'm sorry. Sorry, go ahead. Tell me again. What all is the appeals court looking for?
The appeal court can also rule that the defendant's attorney was incompetent or didn't do a correct trial. There are other things.
Is that why ineffective counsel is always listed on every appeals?
Yes.
Okay. So mistakes, ineffective counsel, any other ones you can think of?
There are a lot of things. I mean, if the mistakes by either the judge or the prosecutor. One of the prosecutorial misconduct is another means of having a case overturned on appeal. Prosecutor's doing his closing statement, sums up the evidence and says, I don't see how any of you can find this guy guilty. That's the prosecutor is telling the jury what the jury has to find or what the jury should find. And that could be prosecutorial misconduct. Or the prosecutor says, even better, the prosecutor says, I've presented you this case, and in my mind, there is no way that you can find this defendant guilty, not guilty. That's prosecutorial misconduct because he's trying to substitute himself for the jury.
Okay. So tell me now, like when I was going back to the question a while ago, jury finds me guilty, and judge says, no, I'm issuing an acquittal from the bench, not guilty. And then in my state, the prosecution has the right to appeal. So when it goes to the appellate court, what does the appellate court, what are they looking for do they look at the same things that the judge looked at, or what are they looking at the reason the judge made his decision?
Well, they're looking at the same thing the judge was looking at. They're looking to see, if they can say, yes, the judge is right, no reasonable jury could find that, then they can uphold the judge. But
so instead of, I'm sorry to cut you off, but so instead of like appealing your conviction where they're looking at mistakes are made, the appellate court's actually looking at the evidence in this case.
In this scenario, the appellate court would have to look at the evidence because the appellate court would have to make the ruling that this judge ruled, took it upon himself and misruled. His ruling was a breach of judicial discretion. So they would have to look at the evidence. They would have to look and see if the judge could make that decision or should make that decision.
So let's say, and I don't know how many, each state has different numbers of, but let's say there are 7 people on the appellate's court or whatever, and the vote's 4-3 that the judge made the wrong decision. So at that point, it goes back to the trial judge, or is the trial judge's verdict overruled, or what would be the precedent then?
That would be up to the appellate court. The appellate court could do one of 3 things. It could, first of all, it could uphold the judge, but it could send it back and direct the judge to accept the jury verdict. Or if there's issues, it could send it back and direct a new trial.
So even if they disagreed that the judge made the wrong call, they could still uphold it and say, we disagree with you, but we're going to uphold your decision.
No, it couldn't. If they agree that the judge made the wrong call, then they have to send it back for either a new trial or to direct the judge to change his ruling and allow the jury verdict to stand. I would, looking back at the law, if you're finding that the judge should not have made the ruling he did, then 99% of the time I would expect that the appeal court to order the judge to reinstate the verdict of the jury.
Is there anything that the judge has? If let's just say you're the judge and you, I mean, you just have watched this, I know, you're not biased. I mean, you watch this thing and you're convinced this guy's innocence, and you make that ruling, and the appeals court sends it back to you, and you're just like, there's no way. Is there anything the judge can do? I mean, can he appeal it to a higher court than that?
Prosecutor can, judge can't.
But no.
The judge would have the judge cannot appeal. The only people who can appeal are the parties involved. So the state prosecutor can appeal, or the defendant can appeal.
That's right. That's right. So if they send it, all right. So if they send it back, they say, Judge, you made the wrong decision on finding this client guilty. Change your verdict. So the judge has to change his verdict. Then at that time, or judge has to go with the jury's verdict. At that time, then the defense would have to appeal to a higher court.
Correct.
All right. Now, would that go back to the appeals court, or would that go to the state Supreme Court?
It all depends on the state. In many cases, It could very well go back to the appeals court, or in some cases, because the appellate court had ruled on something similar in the matter, it might be able to jump to the Supreme Court.
All right. Now, let's say that happens and the judge has to reinstate it. Does and it may just depend on the state. It goes, does the defendant get taken into custody then, or do they wait for the final ruling to be handed down? Because now you got a guilty saying, guilty.
That depends on the state. I mean, in some states, in some states, if the defendant is found guilty and the defendant then decides to appeal, in some states he's eligible for bond. In some states he's not, depending on the type of decision and the type of verdict and the type of crime that was committed. That's totally state. I couldn't.
I remember I'm sorry, to interrupt you. A couple years ago, I'm sure you remember when they was retrying a lot of these cases. Remember Edgar Ray Killen it was civil rights cases in Mississippi. I think he finally got convicted in 2005. But he was convicted, and while they were waiting on his appeal, he was out on bond.
In some states, yes. In some states they can. In some states they can do that. In some states they can't do it. I think most states would allow him to be out on bond if the judge or somebody agrees to it, or if the council that makes the decisions on bond, the bail commission, agrees to it. They might be able to get out on bond, but that's. It's the same type of conditions. If they think he's a danger to the community, if they think he's a flight risk, then they won't let him out on bond.
Tell me about this, because I've often wondered this right here. Your client has been found guilty by a jury, and the appellate court has upheld it, and the state Supreme Court has upheld the appellate court. Upheld the appellate court. You do a writ of habeas corpus asking for the whatever circuit court out of your district to look at it. They refuse to look at it. The Supreme Court refuses to look at it. So its appeals are exhausted. And then, so how come I watch on TV and then 12 years later, all of a sudden, judge is granted for a motion for a new trial? If you've already ran your course of appeals, how does that happen? How are they granted a new trial?
Normally, the only way that happens is new evidence is discovered, or there's prosecutorial misconduct that makes the original trial not a fair trial. Do you know there's Brady material. It was a case that I think it was one of the Carolinas against Brady. And that ordered that the prosecution has to show the defense any exculpatory evidence that they have come up with, that they have found. So if the prosecutor does not give the defense that information, and it's determined that the prosecutor had that information at the time, and it's further determined that that information, had it been given to the defense, might have changed the way that the trial came out. That's one of the reasons why a case can go back after so much time for a new trial.
Okay. All right.
There's also if you can show that the jury was tainted. You remember? I don't want to. I want to be very careful with this, but if you remember in the old Jim Crow South, where Negroes could not sit on juries and that type of thing.
Yes.
Then those laws changed. A lot of cases, because the jury pool was tainted and you did not have a jury of your peers, some of those cases could be retried.
And the bad thing about it is they've exonerated so many people that were put to death over that during those times.
Right.
I'm sure you've heard the Scottsboro Boys.
And right, I remember the Scottsboro Boys, and I remember there are other cases that in similar veins. Let's say that you found out that the jurors were bribed to come back with a certain verdict. That case is one that might be overturned. And there are others.
When you were speaking a while ago,
let's say that the Supreme Court. Well, let's take Gideon versus Wainwright. Gideon versus Wainwright is the case for an attorney representing you for a capital crime or a major crime during the trial. Now, before Gideon versus Wainwright, in many states that wasn't the law. Once Gideon versus Wainwright was decided by the federal court, the federal court had to make a determination whether that should be retroactive or not. Some states considered retroactive, and then gave new trials in certain matters, and some states didn't. I don't remember if the Supreme Court said it was retroactive, but I don't believe it did. And then and then there are other things. Let's say the Supreme Court rules that a mentally ill man with a though he's 29 years old, he has the mind of a 5-year-old. Mental illness is a complete defense to intent, and therefore that person might get a new trial based on a Supreme Court ruling, or a person in the same situation might get a new trial based on that ruling by the Supreme Court. So there are a lot of ways it can happen.
A question I was going to ask you, or I wanted to say one thing first, and then a question I'll follow up on that. When you said that about, how as long as it's not federal or something, you commit a crime, you're guilty, and as soon as they say, or you commit a crime you're guilty of, and as soon as they say not guilty, you can walk out and say, yeah, I did it, ha ha ha. As long as it's not federal, that they can admit it. Then there's nothing they can do about it. I don't know. I can't remember.
Even if it's federal, if you're tried by the federal court, and a federal jury frees you, the federal court cannot retry you if you go out and say, "Aha, I beat a federal murder case."
What I meant that was as long as. Right. I'm sorry. I didn't mean to misspeak. I was I was speaking just on a state crime. I'm sorry. I should have said, federal too, that they can't beat you on double jeopardy. My apologies on that. Thank you for telling me or for pointing that out because people might have thought that you've been tried for something else. I'm sorry. So right, there's no double jeopardy. You can jump up and down. I did it. Hi, there's nothing you can do about it. One of those civil rights cases. I can't remember which kid it was. It may have been. I can't think of the boy's name now. Anyway, but it was in the 50s, and they killed this kid in it's 13 or 14, and goes to a jury, all white jury, and this was before the civil rights action, civil rights act, but those guys that killed.
This is
Tillman, yes, Tillman. Those guys went out on TV 6 months later in an interview and said, "Yeah, we killed him." There's nothing they can do about it. And which brought me to a next, for the Civil Rights Act, and so which brought me to the next question because when I was young, a young man. I was following a lot of these guys who had been was finally being retried for acts in the 60s, like Bryant DeBeckwith. I think that was the first one in Mississippi, and then you had the church bombers here in Birmingham. All right, so when they go in there and they get ready to go to trial, their lawyers are saying, "Hey, you can't try him. He has a right to a speedy trial. It's 40 years after the fact. You can't try my client 40 years later." How was the prosecution getting past that, saying we've not violated his right to a speedy trial?
Well, the speedy trial is not made. There are ways to get around the speedy trial issue. If you can't try him for some reason, if he flees the state and he comes back and you catch him 20 years later or 25 years later, as long as the statute of limitations is still okay, the speedy trial issue would fail because it was his own conduct that prevented him from getting the speedy trial.
Okay, but as far as like one of them, Blanton, he stayed in Birmingham, never left, never stayed the same area his whole life. Is that just judge's decision on that, or?
The answer is I really don't know. I would assume that.
Well, I appreciate that. I mean, honestly,
because the statute of limitations for a capital crime that didn't run or didn't toll, that's why they're priming it. The speedy trial is not.
Well, say there was a case that had a statute of limitations went 10 years, and at 9 years, 11 months, and 22 days they file charges. Then you would have a better case of saying, "Hey, his right to a speedy trial, you're violating that. You should have arrested him 9 years ago."
Well, the issue is whether you thought you had the sufficient evidence to arrest him 9 years ago. I mean, don't forget, how many years has DNA been around?
Oh Lord,
so,
yeah.
If you have the guy in California who was just captured because of his DNA. I mean, the last crime he committed was 20 years ago, but the statute of limitations is still on the book. Even if they had, and this guy, they had no clue it was the guy until they found they found some DNA from one of his relatives who did one of these 23andMe things. But if you can't find the evidence, if you don't have any clue, if you don't have reason or reasonable evidence to believe that somebody committed the crime, until you actually get that evidence, that's when a speedy trial issue would arise.
Okay. All right. So, and here's a question for you. I guess it goes back to that one because I studied those cases so close. The one of the appeals, I think, of Blanton, and that his lawyer brought up an appeal. He said he did not have a jury of his peers because he was set with 9 females and 3 black males, and I think it was. I can't remember what the mixture was of females. We'll just say it's 4 black females and 4 white females. And he brought up that he did not have a jury of his peers. I mean, is there a case for that right there, or is that grounds for um, overturning it? I mean, is that still considered a jury of your peers? But
I would not say. I would think that that would be considered a jury of your peers. I would think that that would not be grounds to overturn the case or to grant a new trial. I mean, assuming assuming your attorney was competent and the prosecutor didn't use any prosecutorial misconduct, I would think that that's a jury of your peers.
so, what would be considered not a jury of your peers?
It's much more difficult now. If you can show that the prosecutor has used all his challenges to knock out black voters, I'm sorry, knock out black jurors, knock out certain white jurors because they make certain amount of money, that type of thing. That's what you're looking at these days. You're basically looking at prosecutorial misconduct, and in some rare instances, you're looking at your own attorney being incompetent. But those are the only ways I'd see that issue arising anymore.
Okay, yeah, that makes a lot of sense then. As for that, because that got me to think about about what you said in the back in the Jim Crow era when blacks couldn't sit on juries. Then obviously that would.
I mean, one of the interesting things is when you talk to a lawyer who does capital cases, who does a lot of jury trials, what they always tell you is they try to save at least one challenge. Because normally what you do, you have challenges for cause. Now, challenges for cause would be somebody who knows the defendant, somebody who knows the lawyer, that type of thing. Then you have regular challenges, 2 or 3 challenges that you can use for any reason as long as that reason is not illegal. If you're using them to knock off all the blacks you can, that's illegal. But what an attorney will tell you is you try to not use up all your preemptory challenges, your challenges that are not for cause. Because once you do, once you have no more challenges left and you have to accept anybody who comes on that you cannot get off for cause, then then you're stuck with whoever's there.
Right. Yeah, 'cause I got struck from a jury one time. Uh, Probably about 5 or 6 years ago in a domestic violence case, and I seen the defense attorney outside later. I said, "Hey, why'd you strike me?" And he said, "Well," he said, "the prosecution struck you." And I said, "Why?" He goes, He said, "You're a bartender and you live on the most liberal area in Birmingham." And I said, "Oh, okay."
Yeah, but you were not stricken for cause. You were he just challenged you because he had a challenge that he didn't think that you would be a good juror on for his side of the case.
Right.
Now, if you knew the defendant, then you would have been stricken for cause, and there'd be no issue.
Yeah. If you're, for that, yeah, okay. So I was fixing to say something else about that right there. Striking jurors. Oh, my dad he'd got called for a federal jury case, and it was some drug dealer case, and he was the big man or something, and I guess the prosecution had made deals with everybody else. So we had the three people at their prosecution, and I guess the for the prosecution, and I guess everybody thought they had a slam dunk, and they go in there, and first day there's still no verdict. Second day there's no verdict. Third day they're going in the fourth, and the judge is coming there. It's like, what's going on? And they're like, we're deadlocked 10-2, and they couldn't figure it out. So finally, they had a hung jury, and my dad was one of the people that hung the jury. And I said, you hung it? I said, yeah. I said, what'd you base it on? He said, look, he said, the guy, the defendant's saying, his defense are attacking them, saying they're the drug dealers, and they've made a deal with the prosecution, and why should we trust you? And they keep just hammering him and hammering him and hammering away out there. And he said, destroying their credibility. And he said, I was just looking at it as, why am I supposed to believe these three over this guy when you've not sending him to prison, and you're going to send this guy? So he voted, him and another guy hung the jury, and they declared a mistrial over a deadlocked jury.
Well, that's what a reasonable doubt is. And if all 12 of them had that same reasonable doubt, he would have walked, and there wouldn't have even been a mistrial.
And and I guess some of them. So there was a case here in Alabama a while back that I was reading about, and I can't remember. It was a very, very, very. It would have been hard for me. I mean, people say I'm a defense attorney's dream juror. It would have been hard for me to convict this kid. He gets tried for murder, and it goes to the jury, and the jury is deadlocked 11-1 for not guilty. And when they retried him, they found him guilty. And I was like, oh my God, to think that she was one vote away from walking. And
well, don't forget, new evidence could be discovered between then and now.
True.
I mean, there are reasons. A weapon could have been discovered, a body could have been discovered. I don't know if in Alabama or you have to have an actual body to do a capital case. I know you don't have to in Connecticut and New York now.
Yeah, that good thing you brought that up, because if I remember right, that law came about. And I think it was because Dr. Henry Lee helped out, right, with the wood chipper case back in the 80s or 90s or something with that. Is it the same case?
They ended up finding a fingernail or something, so they actually had part of. I think
it was a part of a tooth, if I'm not mistaken, but it could have been a fingernail on that. But it was just a fine.
Right, but Henry Lee was our forensic expert, state's forensic expert for many years, and he was very big on the Hiley Craft trial.
I believe if one thing too, if I remember correctly, that never would have put them on that is if he hadn't paid for that wood chipper with a credit card.
Yeah, people do stupid things. What they say is, and I have friends who are police and friends who are on the other side, and they tell you that everybody thinks that they're smarter than the professionals. Sometimes they do. Sometimes they get off. Sometimes they make a good deal. But most of the time, if you give the police enough time and enough money and enough evidence, they can put out a reasonable case. And don't forget, in order to arrest somebody, in order to bring somebody to trial, the standard is not beyond a reasonable doubt. That's the only standard. The only time you use that is to convict somebody.
It's probable cause, correct?
Pardon? Probable cause. Absolutely. Yeah. Is it probable that the defendant committed the crime? Do you have a reasonable certainty in some states that the defendant committed the crime? That's what you need. You don't need to say that, can you do it beyond a reasonable doubt? That's something that the prosecutor has to determine.
I'm sorry, go ahead.
The prosecutor has to determine whether he can convict beyond a reasonable doubt.
I got arrested once time, and it was over and because of Alabama and archaic drug laws and some little municipal cop wanting a big name for himself. I got arrested over a $10 bag of marijuana. Uh, ridiculous now thinking all the states doing that. But yeah, I mean, it's to the point, they've got 6 cars out there too. It's like, guys, y'all got the, that serial killer you was looking for. You can take down the roadblock. So they go in and they're when we talk, this chief narcotics officer has these videotapes recorded. I'm like, what are you doing? And he's like, well, I'm doing an interview. I was like, no, we're not doing an interview. And he goes, okay, can we talk off the record? So he starts talking and I was like, I'm still not saying anything. And anyway, once you wear a wire and go make some buys from him, and I said, dude, this is over a $10 bag of weed. I'm not making things about this. So he just goes ballistic. And I told him, I said, look, I'm going to get out of this. I promise you. And he goes, oh, all of y'all talk big like this. I said, no, I can assure you this is going to go away. So I called my lawyer and he said, okay. And we show up to, I don't know how it is up there, but so in this municipality, he did a thing called stipulation of guilty plea, where they admit the municipality would find me guilty, and we will go ahead and take it to district court or circuit court and put it before that judge. So it goes up there. They have like their 3 meetings or something. So it was like right before lunch on this one day, and my lawyer comes in there and goes, I'm having some discrepancies with your case. Just bear with me for a minute. So I'm like, okay. So it's right before lunch. He calls me in there in the private little thing over there. He goes, okay, here's the deal. Will you agree to plead guilty to disorderly conduct and pay a $75 fine if they drop the possession of marijuana case? And I said, that's it. Just plead guilty to disorderly case. He said, guilty to disorderly conduct, $75. I said, yeah. I said, I'll plead guilty to that. He goes, I hate that you have to plead guilty to it. I said, well, it's better than that. So I went in there and I pled guilty to disorderly conduct and the $75 fine. And so I said, so what happened? I said, how did he get down and drop that? He said, he didn't have probable cause to take you out of the vehicle and search you. He said, just because he thought you was in somebody's apartment buying marijuana and having a tag light out, he said, there's no reason to have probable cause and to pull you out and search you and search the vehicle. He said, but I had to throw the DA a bone. I'm sorry you had to plead guilty to that. I said, well, it's no big deal. I said, but thank God that I'm smart enough to get a lawyer. Somebody else would have pled guilty, and then they got a drug conviction on their charge over a police officer committing an illegal search and seizure.
Exactly.
And a lot of people on some of these things, I got set up in these years ago I was bartending. I get set up, and it should have caught my attention. It didn't, but I bartended at this bar, and on Wednesday nights we had jazz music, jazz bands, and we had several really good blues that will, I'll say it, jazz, different kinds of bands, jazz, blues, I mean all kind of music you think of bands. Well, we had several good blues bands that and they had a lot of black followers, customers that come into the bar. Well, it was like on a Tuesday, and 3 people came in, and it didn't throw me off because people were always coming in asking for the upstairs bar, and it was a black man and 2 black ladies with him, and they first thing they did was start asking about the bands. I said, well, that's on Wednesday night. Ordered drinks, and I set the drinks down, and 2 minutes later the doors open up, and these guys have assault weapons, ski masks on, and I had no idea what was going on. And Alabama Beverage Control Board, they could, we're one of the few states to do this, but our state controls the alcohol. They raided us, and they had people searching us, patting us down, everything like this right here for selling alcohol to a minor. So they took my picture, let me sign my own release bond, didn't go to jail. So I called that same lawyer, and he goes, well, we're not taking this laying down. So he pled not guilty, and then there was some other hearing, and we entered another plea of not guilty. So then a trial in front of the judge, it was in Birmingham Municipality Court. The Birmingham judge set up a trial in front of her that was going to begin at this day, 9 o'clock. It was 9 months later. And then so we show up to court, and none of the other ones showed up. So then I had to sign a piece of paper agreeing that I would not sue the city of Birmingham for false arrest and was let go.
Yeah,
But see, most people would just go ahead and plead guilty and take it.
exactly.
Well, that's been a pretty interesting conversation, Larry. I'd like to have you back on some more and talk some more one night about some law stuff with you because, yeah, I mean, a lot of different interesting topics there. I haven't, it's actually been one of the more fun ones I've done. Is there anything else you'd like to add to it before we cut off for tonight?
I'd like to just, I'd like to, a couple of minutes. My
Sure, go
favorite,
ahead. Go ahead, take your time.
my favorite case was a civil case
Yeah.
that I was representing the defendant.
Mm-hmm.
The plaintiff was suing my client, a company, stating that my client put in the wrong type of neon argon lighting for his car dealership. And this
Okay.
and we so we were defending it. We put in 44 lights, and we had put them in 4.5 years ago. And what they did was they got another company to take out our lights and put in brand new lights. And they were trying to have our client pay for their new lights. So what happened was they called as an expert witness the salesman for the new company. So this was a trial referee and who I
Mm-hmm.
knew. So I tried to get the expert witness disqualified as not as an expert, but the referee wouldn't do that for me. So we tried the case, and the first thing the guy testifies to as an expert is there are 5 types of neon argon lighting that could be used. And so and we all know what we used. So the expert has never seen 2 of the types of neon argon lighting, so he can't determine whether our neon argon lighting was one of these 2 or one of the other 3. So that's okay. So basically, I've discredited the witness, but the judge is allowing and the trial referee is allowing to go on. Then I asked him, what is the standard life for a neon argon light? And he says 3 to 5 years. So I said, you've listened to the testimony here. When
Yeah.
did my client install the lights? And he said 4.5 years ago. So,
Wow.
and how many of those lights were working when you changed them? He said 40 out of the 44 lights were working. So I said, in other words, you have lights that were within their time frame. So the time frame was 3 to 5 years. You took those lights, you took out working lights to replace them, and then you say that our lights are substandard. So the trial referee made us write briefs, and I made the brief, and the trial referee actually quoted my statement for my statement to find in my client's favor.
Good job, Larry.
Yeah, that was one that was I guess that was about 20 years ago, but I've always liked that case because it was fun just to discredit a quote expert witness. Now I've been an
I bet that
expert
is
witness.
fun to take down an expert witness.
Yeah. Now I've been an expert witness. I've been an expert witness on bankruptcy, real estate, and professional ethics. And I
Huh.
was never quote taken down as an expert.
Um, and yeah, let's keep going for a few minutes. Because that's got me to a few things I want to ask you too before we stop this. First one is I want to ask you because we discussed this the other night when I was talking about Larry Langford and how good he is, and about you never put your client on the stand.
Right.
Do you not think that? And you just I'd have to I'll send you some clips from him. Just watch him. I mean, this guy was smooth. He was an actor. I mean, he could sell sand in a desert. I mean, but you're sitting there
Right.
like, okay. So I mean, you don't ever think, you can when things are, you feel like things that this is not heading our way. I mean, you don't see a situation where you're there and like, man, we need a Hail Mary. This guy's his own best friend right here. I mean, put him on the stand. I mean, if you know you're going to get a guilty verdict, why not just take your chances and try to get a Hail Mary with him? Because if you just knew this guy, if anybody could have talked their way out of it, it was him. I mean, this was the Obama, Clinton, Reagan, Kennedy
Right.
speaker wrapped into one.
The only issue with putting your client on the stand is you're in effecting taking away his presumption of innocence. Now, in a criminal case, you get and this is prosecutorial misconduct. If the witness does not take the stand in a criminal case, you can't draw an inference about that. And if the prosecutor says, "Look, he hasn't taken the stand to defend himself," that's prosecutorial misconduct right there. It's gonna be a mistrial, or if it goes to the jury and it's convicted, it's going to be thrown out on appeal. But that's only because the prosecutor told the jury that they can take a negative inference from him not taking the stand. Now, you can do that in civil matters, but you can't do that in criminal matters.
Right.
Yeah, there are reasons to have your client take the stand. A trial that I was on was a four-person trial from stealing a briefcase at an airport. And we thought we did a marvelous job in defense, in cross-examining the prosecution's witnesses and everything like that. So the four of us, there was four different attorneys, we decided that we were not going to allow our clients to take the stand. The court officer came to the lead attorney, who was, his last name was Master Piero, and he was the Queens County Commissioner, as well as being a criminal attorney. And they knew each other, and he said, this judge will, even though he's not supposed to, this judge will not give you a fair shake unless your clients testify. So we took this guy's word for it. We put our clients on the stand, and we won the case. So, we didn't have any issues. Personally, I didn't even want to do it then, but my client basically wanted to testify after what the guy told us, because I was honor bound and duty bound to tell him what this guy told him. But normally in a criminal matter, and even in a juvenile matter, if I could help it, I would never put my client on the stand if my client was a defendant.
Yeah, I know that's, and I've always heard that, you see it in rarities. I wished, I wish I could explain Larry Langford to you. Just the charisma and just the way the presence this guy was. I mean, he was just amazing. And
no, I understand it. I understand that. But the more important thing was when you told me that his three alleged co-defendants all turned state's evidence against him.
Yes, they all turned state's evidence against him, and here's where I thought that he had them. Larry was not. Oh, I'm sure Larry got some money or everything. Larry was not the type that money didn't motive. Money was not the thing that as far as bribing that he liked. These guys got probably made $7 million off some of these deals. Larry got some suits and some jewelry and stuff like that. That's how they was supposedly getting Larry. And his why his trial judge did this or why his attorney did this, I don't know. There was a guy here in Birmingham named Emory Anthony, and he is the Johnny Cochran of the defense lawyers here. I mean, smooth, kind of even sounds like Johnny, $1 million smile. And if you're going to court, you want Johnny, or excuse me, Emory. And
Right.
Emory offered to represent Larry pro bono, and Larry turned him down. Like I said, this would be like Cochran offering to represent you. And he hired this retired federal judge. And the judge, the first thing he did, and why Langford agreed to it, to this day I'll never admit, he had the trial moved out of Birmingham to Tuscaloosa. All right, now let me explain a few things. That there is a Birmingham Tuscaloosa rivalry. They do not like each other. Cities of Birmingham, cities of Tuscaloosa, they don't like each other. Larry probably had, if you was to guess, a 90% approval rating in Birmingham. He had just won a mayor's race against 8 people and was not a runoff. And I mean, just beloved. And that guy had the trial moved from Birmingham to Tuscaloosa. Instead of Larry getting set on a jury that at least was fairly racially mixed, Larry gets 12 whites. And took them 2 hours to convict him. And I thought, why did y'all ever take that case out of Birmingham? I don't care if you can say a prejudiced jury. Well, yeah, they've been prejudiced in his favor. I mean, why would you do that?
Well, it's a defense attorney who made a mistake, and it could Larry could make a claim about ineffective representation of counsel, and he may have things appeal.
Larry's pills was upheld, and he was released, I think, 2 years ago now on a compassionate discharge, and he died a few weeks after that. Yeah.
But,
and another question I wanted to ask you: we've all heard the saying right here, "Fool represents himself in court." Explain that.
Okay. Basically, if you represent yourself, you're held to the same formats, evidence, everything else than if a lawyer represented you. So if you don't have if you don't have a lawyer, if you're going on yourself, if you're going by yourself and being held to the same standards. Now, the second part of that is a lawyer who represents himself as a fool for a client. And that is the same way, because you're there and you're involved in the case, not professionally, but personally. So
what did I say first?
Pardon?
What was the statement I made first? Because then you said it right. What?
I think you said basically that someone who doesn't have a lawyer has a fool for a client.
Yeah, that's what you said. I couldn't remember what I said first, but that was a statement I meant to make. I'm sorry. Go ahead, Larry.
So no, I understand it. I mean, what you want is, even if you're a lawyer, you want to be represented by a professional. I mean, the cases where I've been sued, and it's happened once or twice, I've been represented by another lawyer. I've won both of those cases, but I would not do it. I would not represent myself.
Speaking of that time when I was telling you about that DUI, I got taken to the jury trial. We first went up there speaking for the judge. The lawyer looked at me and goes, "Don't say too much." And I said, why do you think you're here? I'm not saying anything.
Exactly. I mean, I tell my clients in that scenario, don't say a word unless I tell you to.
So let me ask you this. Let's say, just think of something just generic. A man comes home and um, finds his wife dead. She's been murdered. And the police, he calls the police. My wife's been murdered. I don't know what happened. They get there. The police start investigating what happened. I don't know. I got home, found her here, and so they test hands for gun powder. So take him down to the station. Would you tell? Would your advice be to people answer questions then, or not say a word until you have an attorney present?
I would, my advice would be not to say a word unless you have an attorney present.
Okay. Because I've seen that many times where they start talking and say something and they get them because I would not. I would
Yeah,
not think.
don't
Should they
forget.
even make a statement? I came home and I found her murdered, or
Yeah, you call 911 and you call them in, and you are, since you're there with the body, you're going to be the first suspect.
right.
So I would have my client say absolutely nothing. And don't forget, you have to read the Miranda rights, not when you start questioning, but when you think that there's sufficient evidence to make an arrest. That's when you have to give the Miranda rights.
But what you're saying is, and what I was asking is, as soon as they bring you down, just to ask you, so you got home that night and you found your wife dead, where had you been before? So at that point, you'd say, I'm not speaking anymore until I have an attorney present.
Exactly. That's what I would do. That's what I would recommend.
So, in your
Now,
opinion,
now
I'm
once
sorry.
once he talked to me, and if I believe what he's telling me, then I would have him answer those questions, or I would have the officer submit those questions in writing to my client and have them answer it, or I would answer them. But until I had actually spoken to my client, I don't want my client saying anything.
Very good. I hope everybody's out there listening. So, in your opinion, as a attorney, in which, and I've never thought this to be bad either, I hate to keep saying media, but court TV and people try to portray it bad, and they say, "Oh, they went out and lawyered up." Well, I've never really thought that was a bad thing to lawyer up.
No.
As soon as it happens, you're going to accuse me of it. I'd rather go ahead and be lawyered up then and let them handle do the talking.
Yeah, exactly. I mean,
Yes.
I have, as a professional, I have a job to do. And
Mm-hmm.
that, if I take a criminal case or if I'm assigned a criminal case, I have to do the best job possible for my client. I'm not representing the people, I'm not representing anyone else, I'm representing my client. And my client has my first and my only approbation. I have to do what's best for my client. I have to advise my client if he's making a mistake or that type of thing. But if my client tells me, like Larry in your scenario, if my client tells me that I want to testify or that I'm going to testify, then a lawyer should allow his client to testify, whether I believe he's wrong or not. I mean, the client controls the case. The lawyer does not control the case.
Okay, that's a good point right there. That about that. Um, see, where's I lost it? Lawyering. I forgot the question I was going to ask you about. Yeah, it was about when they come home, they start questioning you. Um, and uh, huh, I totally lost what it. Gosh, I hate it when I do that because I have two questions on my mind, and
Give me a moment.
and then we'll lose one. Um, uh, dang, it's right there on the tip of my tongue. About what being questioned by. It was about when you're being questioned by police and when to not make a statement or not say anything. I don't know. I can't remember. So you said at the time they're going to make an arrest is when they make the Miranda rights, but anything that you've said previous to that can still be used, correct?
Maybe.
Okay. Oh, I remember the question I had for you because this guy remember the night I had a great interview with Sean DeGrilla. You should check it out on there. He did wrote a book called Malcontent, and it was based on the voice stress test analysis that they did on Lee Harvey Oswald.
Okay.
And it was it's about an hour long, but check it out. I mean, it's pretty good. He talks about anyway how he was guilty. Since they are not admissible in court. And would you ever give your client the advice to take a polygraph test?
Since they're not admissible in court, I don't know. I really don't know. I'd have to think of the situation. I've never had a client who either asked for a polygraph test or the police never asked for me to make my client available for a polygraph test. So it's it's something it all depends on the scenario. I mean, I would probably not have my client take the test unless I was 100% sure that he was not guilty and he wouldn't say something stupid. But, thinking about it, I would probably advise him never to take a polygraph.
Yeah, because I've read about people who take a polygraph and fail that was telling the truth, and people who's taken, who's telling the truth and pass. And I don't see what anybody has to gain by taking it. This is not admissible because somebody brought this up to me about the Ramsey, and I think it was the Ramseys. It could have been a different one, but not taking a polygraph test. And they said, well, that just made them look like more suspects. And I said, well, they were already suspects. The kid was found dead in their home. I mean, what the polygraph is not going to do anything to help you at this point.
I mean, that makes them the first suspect.
Yeah. They're the number one. There's already, the top suspect. This polygraph is not anything and you're, going to do any good for you one way or another. I wouldn't take that. So that was just, my question, why people agree to take these polygraphs, if they're not admissible.
Well, a lot of people don't talk to a lawyer first. And a lot of people think that the police are trying to be fair.
Oh, yeah, that's funny in that time. They do that, buddies, good. Oh, man, it's okay and everything. And the cop said, when I got the DUI, I said, so what are you under the influence of? I said, well, you're the policeman. Why don't you figure it out? And he said, what? And I said, well, I'm not doing my job for you. And because I'd refused to blow on the breathalyzer. Because a lawyer, I don't know how it is there, but a lawyer advised me one time. He said, never take a field sobriety test. He said, if you've been drinking at all, never take a field sobriety test. He said, and never blow on a breathalyzer. He said, because if they get you out to take a field sobriety test, he said, at that point, you're going to jail. He said, they're going to find something to fail you on it. He said, and you're going to fail the breathalyzer here. He said, so go ahead and refuse. He said, so, they're going to take your license for 90 days, which they still would, if you failed it. He said, so go ahead, refuse both of them and go to jail. Now they don't have the sobriety test and they don't have that right there to go on. He said, they will use that as evidence, but we will also counter use that as evidence that they don't have it.
Right, exactly.
Well, I don't know if that was something. And again, everybody don't take my word for it. I'm not advising you to do it, but I wouldn't. I didn't take the test on it. So that's been that's been some real fun. I have to have some more court cases like that, man. Is there any other ones you want to add on that before we close tonight, Sal? We've been going almost 2 hours, and I don't want to keep you on.
We could do. I've had a lot of cases I did, but the one I told you about, the one with the expert witness, I really enjoyed, so that's why I wanted to bring it up.
Well, we got to cover that.
One other case. This was a bankruptcy case. It became a bankruptcy case. Now, for the last 30 some odd years, probably 30 to 40% of my practice has been bankruptcy, but I still do civil litigation. So a client came to me, and he came to me 5 months after a default was entered against him. Now, in Connecticut, if you come to an attorney, I'm not sure if it's 30 days or, 90 days or 120 days. I believe it's 120 days. But if you make a motion to open a default before 120 days, it's a much easier standard than if you make the motion after 120 days. So I'm representing a husband and wife. He runs a construction firm. She's his bookkeeper. The plaintiff sues both of them for money damages to mistakes made in the building of her home, or the renovation of her home. So they come to me. We make the motion to reopen. Obviously, they came to us too late, and the judge finds against us, which was not unremarkable. And then we go to what's called a hearing in damages. They've already found litigation, but now they have to find damages. One of their claims was an unfair practice claim under Connecticut, which they're entitled to counsel fees. So we took the case to trial. We did a phenomenal job. They awarded him about $10,000 in damages, but they also awarded them 40 some odd $1,000 worth of counsel fees. So,
oh, wow.
We couldn't, it wasn't worth our effort to appeal. So what we did, they were separated, getting a divorce. So we filed them both in bankruptcy. Now the husband had no assets and no property, so he was discharged, and she couldn't collect about him. Now the wife had bought a house with her son, her and her husband's son, and daughter-in-law, and she was a 1/3 owner of the house. So we filed for bankruptcy with her because the house was valued within her exemption. So she could keep her third of the house. And we filed the bankruptcy. The plaintiff in the other case got an attorney. The attorney was allowed to get a new appraisal of the property. The attorney got a new appraisal of the property, and the property was worth $35,000, $30,000 more than our appraisal. But the issue was that even with the $35,000 more, it only added $12,000 to my client's exemption, which my client had an exemption of, I believe it was 18,000 at the time, maybe it's 20,000. So we were still able to get her off the hook. So even though we had we lost the motion to reopen the case. We technically won the trial, but they hit him with a huge verdict for counsel fees because we couldn't oppose it. All it was were the counsel fees fair, and it was a 3-day trial, so the counsel fees were fair. So we were able to actually get them out. We were able to use the bankruptcy in this way as a shield to protect her house. So I was very pleased with that result.
I bet you are. That is pretty amazing right there.
And believe it or not, I kept in practice 5 months longer than I was going to just to finish that case.
That was a great one. Well, all right, Larry, this has been amazing, man. We're gonna have to do some more, talk about some more cases. I really appreciate you coming on tonight.
Oh, my pleasure. And I really enjoyed it. I'd like to do it again sometime.
Yeah, and I would too. We got some good things. Um, but yeah, thanks for coming on. We'll talk to you soon, Larry.
Okie doke.
All right.